I'm Jenn Newman, and these are my Candid conversations. Today I'm speaking with Michael Halliday, attorney at law with Morris Hall, and we're diving into the nuts and bolts of the importance of estate planning. Hello, Mr. Halliday. How are you?
Doing well, Jen. How are you?
I'm well, thank you. I wanted to meet with you today. You have been Jim and my attorney in terms of dealing with our estate and with our estate planning, I should say. And I have found all the things that you have shared with us so valuable, and now looking back in retrospect, incredibly timely to what's going on with COVID-19 and the decisions that need to be made. So I would love for you to introduce yourself to our folks that are going to be watching, and then let's dive in with some questions.
Sure. I'm Mike Halliday. I'm one of the attorneys at Morris Hall. We are a estate planning law firm. We only handle estate plans, as well as when people pass away, we help them with their trust administration, or if necessary, their probate administration. I'm one of 10 attorneys, and we have offices all over the Valley, as well as 3 in New Mexico. I've been doing this since 2004. I started up in Oregon, practicing with my own practice, and then we moved a couple of years ago to Arizona, where we're native to the East Valley. My wife and I have known each other since high school. We've known you for quite a long time too, since college.
I was just going to say, I did the math today, and I don't know if I want to repeat it. Mm-hmm.
Right. We don't have to.
Okay, yeah.
So we enjoy being back. We're glad to be back in the Valley of the Sun, and glad to be here at Morris Hall. It's a great firm to work for. We're members of what's called the American Academy of Estate Planning Attorneys, which is a national organization that only licenses a certain amount of law firms, about 150 nationwide. We're one of 4 in Arizona. The Academy has attorneys and accountants on staff, and they keep apprised of all laws changing, cases that have come down from the Supreme Court that affect estate planning, and in turn, they keep us up to date. So we're able to stay on top of things with their assistance so that we can help our clients and guide them the best way possible.
That's incredible. So one thing that I know has come up for a lot of people during something global like COVID-19, where healthcare is such a making tough decisions is definitely part of the equation. I would love for you to explain, the power of knowing that you have those documents, having a healthcare power of attorney, and what that means, and understanding how, essentially, what kind of relief that can bring, knowing that your loved ones are being taken care of the way that they are asking for.
Okay, yeah. Right now, we get a lot of requests for people to come in and do their healthcare documents. When we say healthcare documents, we're referring to 4 documents. The living will, which you get to designate the kind of care and what you want to receive if the only thing keeping you alive is some artificial machine, breathing, feeding tubes, things like that. Number 2 is your healthcare power of attorney. This is where you designate those decision makers that you trust and that are going to carry out your wishes named or specified in your living will. It's also a place where you can make decisions about burial versus cremation, an autopsy, things like that, that most people don't want to think about, obviously, but are helpful for those coming later on. The 3rd document we provide is what's called a mental health care power of attorney. And the main purpose of this is to allow your decision maker, your agent, to place you in a facility if it ever became necessary. I usually give the example of someone needing a mental health facility, like a memory care unit. As you grow older, if you had Alzheimer's, dementia, you have 2 options as a family member, even a spouse, to place that person in a facility. You either go to the court, get appointed as guardian, and ask for the court's authority to place that person in a facility, or you can grant that authority ahead of time through the mental health care power of attorney. So most people opt for that simplified process. Then the last document is just your Hipaa authorization. This allows you to make a list longer than your agents of who you would allow to have information. Call the hospital and say, hey, How is my aunt or my sister Jenn doing? Things like that. They don't necessarily have any decision-making authority, but they can at least find out the information about you.
It's incredible. Yes, when you sat with Jim and myself, we sat with us and walked us through all of the intricacies, all the things that you have to think about. It really brought to light for us that we take sometimes for granted how much planning does go into that process. And that when you're not thinking through all of those details, you could wind up in so many different scenarios where you are not fully protected, which is incredibly enlightening. One thing that I also am curious about, what students as a whole have gone through this year, being displaced, and then of course any student who is above the age of 18 who's in college. Something came up recently where I was asked the question, if God forbid something were to happen to a college student, would it a lot of people operate under the assumption that parents just automatically have the right to make decisions. And I would love for you to touch on that. Is that true, or is it wise to actually have documents prepared for a college student as they are of legal age?
It's a great question, and one that most people haven't thought about. Theoretically, once that child becomes 18 and is an adult, it's really up to the healthcare facility if they're going to honor your authority as a parent. I mean, by law, your child is now an adult and are to be making their own decisions. So it would be a great idea and kind of ahead of the curve if parents kind of thought ahead of time, had those healthcare documents in place for adult children as they go off to college, or if they're in college already, getting them prepared and send over to their child to sign if they're away from them right now. Because it's going to alleviate a lot of frustration and possible pain that doesn't have to go through if they're already in place and they can be given to the hospital. And there's not that uncertainty of, will the doctors, will the nurses accept my authority just being a parent versus having something in writing? So it's a great question.
Listen, that was enlightening to me, and just your explanation proves that with a daughter who's 2 years away from going to college, like, we will be having those documents prepared for her for that very reason. And then clearly they can be amended as that child then, has a relationship, has a partner, is married, etc. Then those can obviously be amended at that later date.
Absolutely, and we recommend them getting updated every 4, 5, 6 years. Whether you're a young individual or as you get older, it's good to take a look at and make sure that people you have as decision makers are still who you want as time goes on.
Absolutely. One thing, I grew up with a family that had different circumstances when it came to their final wishes. My husband was a product of losing his mother at the age of 10. His dad was already gone, and his mother had no will. And so he tells the story. I mean, it's a complicated one, as you would obviously intimately understand, as this being what you do every day. It made for it was a very painful and difficult situation for he and his 2 siblings to navigate with no will in place. And then I was always told, you have a will, it'll take care of you, it'll protect you. And I have seen that also not be enough. And so I would love for you to walk us through what this all looks like, because I think there's a lot of misconceptions and a lot of myths around some of these pieces that it's helpful to have some clarity on them.
That's a whole lot of questions all rolled into one, but I'll do my best to kind of parse it out.
Yes.
Unfortunately, your husband's experience is pretty common. Seen it lots of times. In my own family, my grandmother, my mom's side, she passed away when I was a freshman in high school, and she had been living with us the prior couple of years before she passed away. And all I remember is as soon as she passed away, my aunts who lived out of state called up looking for their share of their mom's estate. They hadn't come to visit. They hadn't done anything to care for her. And their first thought was, where's my share of the estate? And there was very little to my grandma's estate. And I just remember, because my grandma didn't have any estate plan in place, that it caused a rift that never healed for my mom and her sisters throughout their lifetime. I mean, my mom was the youngest of her family. Her sisters are now passed away, and they never spoke after that point. And it's kind of gut-wrenching when you see it as an adult now, as an attorney, when we're dealing with other people's families. And kind of now I can look back and have that perspective of how hard it must have been for my mom going through that kind of an experience with her sisters, and how it tore them apart. And that's one reason that we strive to make that non-existent in our clients' lives, is to try and get them set up in a way that brings peace of mind to them and makes it easy for their family. So back to the myths and misconceptions. Having a will is just a small step in the right direction. And the reason I say it's a small step is it does provide some guidance to those coming later. You can designate who's going to be in charge of your estate and where your assets are going to go. And that's probably where the benefit ends for the most part. It is also a place where you'd name guardians for minor children, if that were ever a necessity. The problem, though, that most people don't understand with a will is that it has to go through probate to have any authority to it. So really what you're doing in a will is you're nominating and making these directions that really have to be filed with the court and stamped with approval or given authority through the probate court with the probate judge. So the people you nominate to make decisions has to be appointed by the probate court. You got to take care of accountings and do certain statutory filings. It can take anywhere from a few months to a couple of years to do a probate. It's public record, which means anyone can come in off the street, not related, not anything related to the legal field, and ask for that probate file and get access to it. So there's really no privacy to it. So you're really just a slight step ahead of not having a will. What we generally recommend is a revocable living trust. And lots of people have heard trust and maybe have conceptions that they're only for the very wealthy, the star athletes, or the people in Hollywood. And really that's just not true, especially nowadays. A trust comes in handy, especially when you own real property, you have a home, you have more than $75,000 in personal property, bank accounts, things like that. And the reason I use $75,000 is that is the smallest state amount that's allowed in Arizona to pass without the need of a regular probate. So everything under $75,000 can pass free of a regular court process probate, but everything once you hit that 75,000 mark and over has to go through the probate process. So a trust alleviates that need for a probate by retitling your assets in the name of the trust. So your trust is now the owner, and you individually, or you and your spouse, are the owners as trustees of your trust. So when you pass away, there's not a need to go to the court to get authority for those coming later to make decisions for you. They're called successor trustees. The trust already grants that authority within the document. The assets are already in the trust, and so those people who you've chosen to make the decisions are able to now jump in and access bank accounts, put a house up for sale, transfer the deed, things like that that you would have to go through the probate process if you didn't have a trust. They can do almost right away. So it speeds it up. And in addition, it doesn't require any sort of public filing. So there's not a public record. It's a private process, which most people prefer. And, all in all, it's a lot simpler and quicker process. It has gone long for, like a probate, maybe family members not getting along. Sure. So it can take longer, but that's just going to come on a case-by-case scenario. Typically, taking the court out of it, you're going to save expense, you're going to save time, and you're going to bring yourself peace of mind, and especially those coming after you.
Sure. Yeah, absolutely. I was amazed. I had misconceptions of what a trust was for, and I also had misconceptions until you were able to explain to us what assets needed to be transferred into the trust, how that all worked. I had my own misconceptions. So it was incredibly helpful for us to understand the value And again, it goes back to peace of mind, knowing that when circumstances come, everybody's taken care of appropriately. And that's huge.
Absolutely. And part of the joy that I like is meeting with people and kind of enlightening them, educating them. We get to meet with lots of different people right now. It's more like we're doing now, Zoom or phone meetings. But we get to educate them and kind of quell those misconceptions so that all of a sudden they're like, oh, had I known that earlier and it wasn't so difficult to do this, I probably would have done it sooner.
Right.
And so we're able to answer those questions and hopefully make it a pretty easy process.
That is very true. Not only an easy process, but actually not this heavy, depressing, morbid conversation. It actually is very much like we are protecting the future generation, it's protecting that future. I was able to walk away from that experience not feeling like it was doomsday. It was quite the opposite, which was awesome.
That's good. Good to hear.
Yeah. See, when it comes to real property, obviously that's the business I'm in and day out. And I've had several clients who have purchased property and then transferred into the trust upon closing. And so my question for you is, especially in a state where we have multiple ways to take title, I think that I would love to hear basically why it is important to make sure that A, you're taking title the right way, and B, if you do, for example, take joint tenancy with rights of survivorship, why you want to make sure that your documents are in order when you do take title in that way.
Good question. Again, packed full of a lot of curves and
twists and turns. That's right.
Yeah, I'll do my best to break it down. You want to make sure the title is correct. I mean, that's first and foremost. If your goal is to own it as joint tenants, then make sure it's titled properly. Here's some recommendations that we generally tell clients, or at least get them to think about. With joint tenancy, essentially, whoever survives between the joint tenants, whether it's 2, 3, 4 people, gets the property. They're the winner. So as an example, if it was a husband and wife that owned it as joint tenants and they had 2 children, husband passed away, now wife is the sole owner according to the joint tenancy, but husband's will maybe said that he wants that house to go to his children from a prior marriage. Unfortunately, at least for those children, they are not going to get that house because the joint tenancy designation is what's going to determine where that house is going and who has or holds legal title to that house, in spite of the will stating otherwise. And you could take the will through a probate process and it's still going to come back with the wife owning the house. So title is important, making sure your estate plan matches what the title says. Mm-hmm. Here in Arizona, we have the benefit of owning assets as community property. Mm-hmm. And so community property gives you an added benefit of, similar to joint tenancy, is the survivor gets the full ownership upon the joint tenant or tenants passing away. But they also get, if it's a married couple, a step up in tax basis upon that first spouse dying of the whole property. Meaning if they had paid $200,000 for that property 30 years ago, and when the first spouse died, it was worth $250,000. If it was owned only as joint tenants, only the deceased spouse's share would get a step up in basis. Mm-hmm. If it's owned as community property with rights of survivorship, then the whole property gets a step up in basis, meaning that surviving spouse takes the tax basis in that property of the current value, that $250,000. So if she needed to turn around and sell it to downsize and sold it for $250,000, there would not be a capital gains tax. So she avoids that. And so that's something to consider as well. What we generally recommend is to put it into a trust. Mm-hmm. That way, in my prior example, if the deceased spouse intended it to go to children from a prior marriage, or to allow his current wife to live in the house and then go to his children, then it's all in one place. It's all spelled out and everyone understands. Everyone's on the same page. There's not a question as to where that house is going. And so we want to make sure that it's titled into the trust properly if you have a trust. As a side note, one of those things that we make sure clients understand is a trust is only as good as what is in the trust. So you could have a fancy, really robust, nice trust, but if you don't transfer your house into it or bank accounts, investments into the trust, then it's really just a lot of nice pieces of paper with some writing on it. So we admonish clients and help them get their trust funded. So just to make sure it carries out their wishes. Sorry about that tangent.
No, it's important because we recently realized that we have neglected to put something in it. We realized, oh, we never did that. And it's true. And I've been in situations on the real estate side, same thing, where there are issues where something wasn't titled properly. And when it comes to that period of time, a family is already they have so many other things to be processing and thinking about. And that emotional process is sacred. And when you are trying to handle, I had a circumstance where the person had not passed, but was incapacitated. And so watching what that family had to go through in order to sell the property was very challenging. And it could have been simpler in retrospect, as I look back on that example. That could have saved so much pain for that family had those documents been in a place where they were in order to protect everyone involved. So I will say, I don't think it really resonated for me, the need, especially at our age, to get this detailed until I started to see what happened in real time with families in real estate, and understanding that it was like a magnifying glass. It really kind of illuminated that fact of how necessary it is to have everything in order.
Yeah.
Are there different kinds I know we talked about this when we met with you, but can you just touch upon what kind of trusts there are? Are there more than one? Are there different kinds? And is there something that people need to look out for when they're considering establishing a trust?
Great question. There are many, many different trusts. I'll tell you, we do many different trusts, but the most common is just the revocable living trust. We do two types of the revocable living trust. One is what we term a probate avoidance trust. So its main purpose is to avoid probate. So everything's owned by the trust. After both trustors or owners of that trust pass away, if it's a married trust or if it's a single person after he or she passes away, then the assets go directly to their beneficiaries that they've named in the trust. Compared to what we call a legacy preservation trust. And this is just a little bit more robust trust. It has some asset protection for a surviving spouse if it's a married couple, and asset protection for beneficiaries who are inheriting the assets. So instead of after the trustors, the ones creating the trust, pass away and it going outright to beneficiaries, in this type of trust, it continues to be held in what we term a beneficiary trust. And those beneficiary trusts provide some asset protection for those beneficiaries, some creditor protection, protection from bankruptcies, divorces, and protection from the individual, the beneficiary, if they have, let's say, an alcohol or substance abuse problem, or if they just don't manage money well. Provisions can be added to that trust so that that money that the family has worked hard, a lifetime to generate and acquire, isn't gone in a split second or, in the first year of the beneficiary inheriting it. So, either type of trust is going to avoid probate. And, we'll sit down with clients and help them decide, what would be best in their scenario. And, going backwards a little bit, there may be a circumstance where a will is the best thing for a client. And so we'll do wills for people as well. We're not only going to have you come in and say, well, you have to do a trust. We're going to give you the option of a will, the different types of a revocable living trust, and then kind of let you decide. And that way you feel good about it and feel confident that you're getting what you wanted based after our recommendations are given to you.
Love that. What can people do what can people do if they want to reach out to you? I'll make sure to include your contact information. Is it an option for people to meet with you and just have a consultation and determine how that works, just to go through, or if they already have documents, can you review and then advise accordingly? What does that look like for people coming to you?
Yeah, just what you said. Right now we can set up a Zoom meeting. We can set up a phone conference. And later on, when we return to some normalcy, you can come into the office as well. So they can call our office at the number that I assume you'll give to them. It's just 602-249-1328, and set up an appointment. And usually, if you want to talk to me, you can just mention that you want to talk to me. If you're looking for a specific attorney in an area, like I say, we have offices all over the valley. So if you want to talk to that attorney specifically, you can. But our consultations are free. So you can call up and we'll spend some time with you, answer your questions, kind of give you our recommendations based on what you've given to us. And then we'll invite you to make a decision. Do you want to move forward? If not, that's okay. Keep us in mind for later on.
Love that. Well, I know that you have provided such value and peace of mind with your advice, with your expertise, and simply put, with your manner in explaining things and making it so digestible. I know how much value that's added to our family, and I know that's what you do for everyone. So it's greatly appreciated, and I hope that you can continue to help people that I know establish the same, because it's been very helpful to others as well. So I appreciate it very much.
Well, thank you for saying so. And you're easy to work with, so I'm spoiled from that regard.
Well, thank you. I appreciate that. Jim might have to argue that I'm easy to work with, but that's fair. We'll go there. We'll go there for sure. Awesome. Thank you so much. And I will provide the ways for folks to get in touch with you, and thank you for taking the time to help explain things even further.
I appreciate the opportunity, and thank you, and stay safe.
Absolutely. Likewise.
Okay.
Thanks.